Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-5150 et al. Maria Esparraguera, appellant versus Department of the Army et al. Mr. Walker for the appellant, Mr. Hinshelwood for the appellees. Mr. Walker, good morning.
Thank you. Good morning. May it please the court. Lucas Walker for appellant Maria Esparraguera. The Civil Service Reform Act says that career senior executives may not be removed from the senior executive service except for the grounds stated in specific statutes, such as performance under Section 3592 and misconduct under Section 75. That guarantee makes career senior executives, like Ms. Esparraguera, removable from the SES only for cause, not at will. It gives them a legitimate expectation of remaining in the SES unless they do something warranting removal under one of those statutes. In other words, it gives career executives a protected property interest in their career SES appointments. As a result, Ms. Esparraguera could be deprived of that property interest. Her career SES appointment could be taken away from her only through constitutionally adequate procedures, including meaningful notice and opportunity to respond before being removed from the SES. But she did not receive anything like that. The OSC report that supposedly justified her removal was deliberately withheld from her. So were the results of the department's own investigation, which cleared her of the prohibited personnel practice OSC had accused her of. Wasn't afforded an opportunity to defend herself or the decision makers who rated her unsatisfactory and ordered her removal, and her supervisors, who were supposed to be consulted and continued to think that she was one of the best senior executives that they had ever encountered, were also cut out of the process that decided her fate and destroyed her 35-year career as a highly respected government attorney.
No. Please. Is there any source of criteria as to what constitutes acceptable performance?
Yes. So the term here in Section 3592 is less than fully successful executive performance as determined under subchapter 2 of Title 43. So it leads back to the systematic appraisal system under Section 4312 through 4314. And it refers specifically to, so it's a 5-level rating system.
What is the top level?
The top rating, the top level is 5. So it's 5 is outstanding, which is what she was originally rated. 1 is unsatisfactory. And those different levels are rigorously defined through OPM and Department of the Army regulations.
So what would constitute fully successful performance?
So fully
I think it
successful,
would be 5. Right?
it's fully successful is level 3. It meets expectations essentially. And this is, you can see this.
Meeting expectations is fully successful. Well, then what's 4 and 5? You said
4 and 5 is basically exceeds expectations, and 5 is outstanding exception, which is what she was originally rated at level 5. And those different levels, they're not just a general feeling about how someone feels about how she's doing. It's a systematic appraisal system that it has to be defined what each one of those means. And so
what was the last rating, if you will, that's the right term, before it went to the head of the agency?
I'm sorry, I didn't catch
What was her last rating before, or recommended rating, before the head of the agency rendered a decision?
So her initial rating official rated her 5, and then there was the performance review board, a specially convened review board that we didn't know about until after it made its recommendation. It recommended level 1 unsatisfactory, and that is what
They recommended what?
Unsatisfactory.
Unsatisfactory.
Yeah, and so that was based on documents we didn't have. We didn't even know that they had been convened at the time that.
Well, be that as it may.
Yes.
Rated as unsatisfactory, which is obviously less than fully successful.
It is, yes. But that standard, that's a performance standard. Performance standards are regularly viewed as being for-cause standards. And here, if you look at the regulations in addendum 25 and 26 of our opening brief, you can see how they actually define what each one of those levels mean. And in JA 49, her appraisal for the year in question. It also provides definitions of what each of those levels mean. So it's the sort of standard that you could invoke in a hearing. That's the kind of understanding that gives rise to a legitimate expectation of remaining in your position under cases like Perry versus Sin. And I would say it is much more rigorous and more carefully defined than performance standards that have been found to establish property interests in other cases. So
can I just direct you to Griffith? Seems like that's probably the best, if not one of the best cases for the government here. And I appreciate that that involved what was effectively a promotion rather than a demotion. But apart from that, do you think there's a meaningful difference in the legal schemes in terms of whether they actually constrained the agency's decision-making?
yes, so I do think that the promotion versus demotion standard was very important. But in addition to that, Griffith was very clear that the acceptable assessment that could lead to a pay raise there was not tied to the systematic appraisal system that generally was used to evaluate employees, that 5-level system that we have here. And it's a very similar system for non-SES employees there. And I would just, that I can point you to the provisions that talk about that. So 5 CFR section 430.305A6, it describes that 5-level grading system. The department regulations that are in the addendum of the opening brief, and as well as JA 49, all have pretty rigorous definitions of what they are. And it's extremely close to the performance standards that govern non-SES employees. So those are in 5 CFR 430.206 and 207. And so you can actually compare a lot of the characteristics that have been found to create a property interest, because performance is a for-cause standard for non-SES employees, apply essentially on the same terms to SES employees.
I take it that the reason for referring any matter, forgetting this one, that the path of to discharge running through the head of the agency is so that the head of the agency may make a determination other than the one recommended by the next level down.
Yes, yes, that is certainly part of it. But what matters is the process that leads up to it, and whether we had a meaningful opportunity to have notice of the proposed action.
Wait a minute, you're assuming there's a due process in time.
Yeah, yes.
So
yes.
let's not assume that. Let's talk about whether there is, which is contested here, in view of this structure and this scheme in which the agency head exercises the final judgment, if you will, notwithstanding anything recommended to the head. Now, in this case, accepted, he or she, I don't know what was accepted, the last recommendation, unsatisfactory.
Mm-hmm. So,
but could equally have rejected it, correct?
It could, but I think there's two important points there. So one is the entire appraisal system is designed to—
Speak up a bit, I'm sorry.
The entire appraisal system is defined to provide objectiveness and consistency throughout. This is why it's defined, has defined standards and criteria. It's why, it's not the head of the agency. It doesn't say the head of the agency makes the determination. It can be a lower official. So that's another reason it's different from Griffith. But even apart from that, has to listen to the recommendations of the performance review board, who is supposed to have heard from the person.
Is there any case in which, under these various personnel schemes that have been reviewed, in which a decision that was allocated to the head of the agency was found and held nonetheless to create a entitlement?
So I think the Federal Circuit's decision in Brenner is actually pretty on point there. So that involved—
That was a state system, was it?
Sorry?
Was that a state personnel system?
No, it involved the VA, the Department of Veterans Affairs.
Yeah.
And 990 F 3rd at 1312 and 1322 and 1329 are kind of the key points there. And the Federal Circuit recognized that there was a property interest and therefore due process rights where a VA employee could be removed if the secretary of the VA determines that the performance of that employee warrants removal, suspension, or demotion. So that was a pretty general standard. It was vested in the head of the agency, and there was no question there that supported a property.
And that was Federal Circuit, you said?
That's a Federal Circuit decision.
Yeah. So Last case in this court, as I recall, understand, to deal with the question was Griffith. Right?
So Griffith did involve a related question. I think there are the three characteristics. In fact, the three main things that Griffith relied on that are all different here. So one is the appointing authority is not necessarily the agency head. Here, it wasn't the agency head that made the final decision. The statute doesn't require that it be the Secretary of the Army or the Secretary of Defense.
As determined by the head of the agency.
So it's the appointing authority, and that can be someone lower under the statute here. So that's one of the differences. Griffith also said that the standard is pretty vague because it's not tied in to the existing performance review standards. Whereas here, this is directly tied into that 5-level system where those levels are defined by the regulations. And it also involved a pay raise, basically a promotion, which is trying to get something more than you already have. And here we're talking about a demotion for interest in retaining for career SES.
Well, wouldn't due process apply if a person had an expectation of promotion based on the system?
It is certainly potentially.
But then that's not a relevant distinction.
Well, it is. The court actually made clear that it was distinguishing cases that involved, removals and taking away the positions that people already had, and that courts had rarely, if ever, found a property interest in a promotion, which essentially it found a pay raise.
Well, actually, isn't your claim in part that she was deprived of future pay increases or future benefits which are not vested and maybe never would?
So it's the guarantee of higher pay. So if you're in the SES, you're guaranteed to have 120% of what the GS 15 rate is. And she lost that. She lost the higher leave. She lost the right to non-competitive reinstatement.
That's all assuming that her performance would have been sufficiently high rated in the future.
It is contingent on that, but I think that's true in any employment case. There are always things that could happen in the future that might warrant removal, but it doesn't change the fact that here, her career SES appointment could be taken away. She could be removed from the SES only for performance or other causes as defined by those regulations and policies. And so that's kind of the for-cause standard that creates a legitimate expectation.
Thank you.
All right, we'll give you a couple of minutes and Mr. Henselwood, good morning.
Good morning, Your Honors, and may it please the court, Brett Henselwood for the government. I'd like to begin with this court's decision in Griffith, where this court addressed a scheme that stated that an employee was entitled to a within-grade pay increase if their performance was of an acceptable level of competence as determined by the head of the agency, that statute did not create a property interest. That statute is, in material respects, indistinguishable from the one here, where you have a situation where there is a generally worded, quite broad performance standard, less than fully successful executive performance, tied to a set of performance review criteria that ultimately lead to a decision by the head of the agency, applying those broad criteria that is vested in his unreviewable discretion about how that employee's performance will be rated. That sort of scheme does not create property interest. And I think Griffith really, in its, just...
Well, counsel, I think the biggest distinction is that footnote 5 of Griffith says that they were assuming that the performance rating system was not tied in at all. And so what we have to do here is look at the performance rating system. And it's specifically, I think, the most important thing here is the regulations. As your friend said, level 3 is pretty specifically defined as meeting all critical elements, whereas level 2, which is less than fully successful, requires a specific finding that rating official has to find that the person did not meet at least one critical element. And that seems to go far beyond what the court thought was happening at Griffith.
Your Honor, 2 points. First of all, what this court said in Griffith, the footnote in Griffith that my colleague is referring to, the court simply noted that there had been new regulations promulgated and it wasn't taking a view on whether those constrained discretion. And I will say, what I've heard from my colleague today at the podium is somewhat different from what we have gotten in the briefs in this case at this
Can you
point,
just
that these regulations create. Absolutely.
Address the regulations, because
Absolutely.
putting that point aside, the Griffith court very clearly thought the regulations in that case were essentially circular. It said acceptable performance is acceptable performance. And my question to you is, how are the much more detailed regulations here analogous?
Your Honor, a few different points about that. So I think starting from the statute and then working down to the regulation, 4313 spells out criteria for performance appraisals, right? That's the statutory. It's a non-exhaustive list of a few different criteria, which are themselves quite broad. Improvements in efficiency or productivity, timeliness of performance, other indications of the effectiveness, productivity, and performance quality of the, of the individuals, the employees that individual supervises. So very broad
So
criteria.
are you disputing that to give a less than fully successful rating, the regulations seem to say there must be a finding that on one of the defined critical elements of the job, they did not meet expectation?
As to SES employees, Your Honor, I don't know of any provision that requires that. And I'm not sure, frankly, which provision you're referring to that might.
It's Appendix
impose that
D of the
requirement.
regulation.
Appendix D of the Army regulation, Your Honor, says,
Correct.
first of all, again, not an argument that the district court addressed because it's not one that's been raised to this point. But what Appendix D of the Army regulation says is it defines the categories quite broadly in, the same category, fully successful is defined as performance in relation to performance requirements of such quality would be expected only of a proven competent executive. Of course, that person must at least meet requirements for all critical elements, but it doesn't say that simply meeting those elements automatically meets the fully successful standard. And then, Your Honor, I would direct you to the provision at the bottom, D3, use of judgment in the rating process.
Right.
Of course, supervisors, performance review boards, and appointing authorities have substantial discretion in determining which rating levels to recommend or approve. And it's recognized that the rating level definitions will not cover every situation in citing a rating. For that reason, supervisors, PRBs, and appointing authorities will be required to exercise judgment when such circumstances arise. It's very difficult for me to derive any concrete objective standards out of that.
Right. So you think, so to compare that to a statute that says this employee can only be dismissed for cause. Obviously, that statute too envisions a lot of discretion, but it's discretion in identifying whether a standard has been met. And I think the point is that in this appendix, the difference between level 3 and level 2 is fairly well defined in terms of providing the type of, as Griffith puts it, I think, some meaningful limit on the discretion to be exercised. I'm not sure let me ask this. Is there another case apart from Griffith that you think is finds analogous language to not create a property interest?
Your Honor, I'm not aware of specific cases that have addressed circumstances quite like that aside from Griffith. I mean, what I will say is the fact that an agency creates or that the statute creates sort of broad guideposts to try to guide the discretion of the decision maker while expressly reserving and recognizing that these guideposts are not exhaustive, are not going to cover every situation, and that they are not ultimately restricting the decision maker's discretion isn't the kind of thing that would create a property interest. I think you're back to the same analysis this court undertook in Griffith. Now, and again, I would just emphasize the district court didn't address whether these regulations separately create a property interest if the statute does not, precisely because it's not an argument that had been raised to the district court. Now, I'm happy to, but I don't think it matters insofar as, even just from the face of this particular regulation that we've just been discussing, the discretion is evident.
I appreciate those points. So what about, I'm not sure we have in mind the same test. So Perry v. Sinderman says a property interest is created by a provision that says you'll continue in your job so long as you do satisfactory work. Ashton v. Civiletti is very similar. How would that, if less than fully successful is so vague, wouldn't those be insufficient as well?
I think it depends also on the other context that goes into assessing whether there's a legitimate expectation of continued employment based on the particular source of law that's at issue there. So the district court here and quite appropriately looked at other provisions of the CSRA that do clearly create a property interest, unlike this one. It looked at the purposes of this program, as this court did in Griffith. Recognizing that Congress created this system to govern the employment of executives at the highest levels of government service and wanted that system to be modeled on private sector executive recruitment and retention systems, and to have, removals be, as the Senate report put it, legally unencumbered when it comes to these sort of performance-based removals, precisely because of the importance of replacing.
I see. So you don't think there's a meaningful difference in sort of the text if all we had in front of us was less than fully successful compared to inefficiency or the satisfactory work, and instead it's about the specific context of this statute?
I mean, I don't think you can abstract it from the context. I certainly think this standard is quite different from something like, misconduct or inefficiency or neglect. I mean, clearly it's this is a lower standard in that respect. You don't have to demonstrate neglect to, conclude someone is less than fully successful. So, I certainly think that there are gradations here.
Yeah.
But
one thing I'm wondering about is inefficiency. Is that inefficiency versus less than fully successful? Those seem roughly analogous, right?
Your Honor, I think you can be less than fully successful for lots of reasons that have nothing to do with inefficiency, right? That, your performance is not up to snuff. Or, here, Your Honor, you have a somewhat unusual situation in this, where frankly, what the appointing authority determines they have lost confidence in this particular employee based on their conduct, particularly to serve in the position that individual had, namely as chief personnel attorney for the Army, given their conduct in the earlier division chief hiring process. So, I think that is an illustration of the kinds of things that can legitimately lead one to conclude that performance is less than fully successful, and that performance is, that it's legitimate to rate an individual, at that satisfactory or unsuccessful level. If there are no further questions.
Thank you.
Thank you, Your Honor.
Mr. Hinshelwood, why don't you take 2 minutes? I'm sorry, Mr. Walker.
Thank you. So, the question here is whether there are rules or standards or the sort that you could invoke in a hearing and argue that standard has not met and doesn't justify removal. That's Perry versus Sinderman. In Ashton, in Hall, this court found satisfactory performance was enough when it was in the removal context. In Brenner, performance warrants demotion or removal. That was found.
About Brenner.
Sorry?
I want to ask you about Brenner again, because you mentioned it earlier as well. There was an APA claim in that case, right? And it seemed that the statute in question there provided that there must be, that the decision, removal, demotion, or suspension under 714 must be supported with specific reasons. Therefore, absent the articulation of specific reasons, agency action is ineffective as it does not comply with statutory requirements. Anything like that here?
So I do think that here, if you look at section 4312 through 14 of the statute and the regulations, you do find those standards have to be articulated. The process that is supposed to be followed is supposed to, if you look at JA 49 onward, you'll see the extensive explanations that are supposed to be part of that process and that she's supposed to be able to respond to along the way. But I also think that that's really about process. Process is you get a decision that gives specific reasons. It doesn't say what those reasons have to be or how good they have to be. So that's kind of the process that you're entitled. That doesn't define whether there's a
review. They're going to be held to that standard.
Yes, but that's
being reasonable.
That's really the quality of the reasoning or the process that you're getting. The substantive standard was just the secretary thinks your performance warrants demotion or removal. And so it was a much less rigorously defined standard than we have here. And it might require judgment, as the government recognized, but every kind of evaluation requires judgment. It doesn't make it
but the statute here
fully subjective.
Specifically points that out, right? And where was it? At 826. After going through the level of descriptions, performance rating levels, and all of that, supervisors, performance review boards, and appointing authorities have substantial discretion in determining which rating levels to recommend or approve. Authorities will be required to exercise judgment when such circumstances arise. I mean, it surely suggests that there is intended to be here a level of discretion different from what would ordinarily apply.
Well, there may be a level of discretion, and it might mean that the kind of review that you end up being entitled to ends up being perhaps more deferential in some ways because the standard could be a little bit more capacious, but it's still a standard could invoke. I mean, unsatisfactory performance here is defined as repeated instances of falling down on the job and failing to lead people and being counterproductive. Those are the sorts of things that you could tell the person who's evaluating you, if you were given the chance to defend yourself, that you haven't met that standard. And in fact, her supervisors who actually saw her work day to day thought none of that was true. So she'd been able to be given the notice, the opportunity to respond. She could have invoked that standard. She could have persuaded someone to make a different decision. And that's all that Loudermill looks to. Were there arguments to be made that the standard that would justify removal was not satisfied?
What do you think is the best case from this court or the Supreme Court finding a similarly phrased statute to give rise to a property interest?
I would say Ashton versus Civiletti probably is the closest one. It says if you continue to do satisfactory work, that was found to be a performance standard. I'd also point to the Ninth Circuit.
Is that determined by the agency head? Do you remember?
I do not
But it
recall.
would certainly have been a superior.
Yeah. So I don't recall in that one. In Brenner, it was by the Secretary of the VA. It was the agency that specifically made that call. And the Ninth Circuit's Wheaton decision also had a very similarly worded standard in terms of performance and satisfactory.
All right, thank you.
Thank you.
Case number 23-1052, Evergreen Shipping Agency America Corp. And Evergreen Line Joint Service Agreement petitioners versus Federal Maritime Commission and United States of America. Mr. McGovern for the petitioners, Mr. Huey for the respondents.
That's stated. That podium we're having trouble with. It's very hard to
Your Honor, it is up.
hear. Good morning, Mr. McGovern.
Good morning. Morning, Your Honors. May it please the court, Robert McGovern on behalf of the Evergreen Ocean Carrier petition. In the challenge decision, the Federal Maritime Commission found that ocean carrier Evergreen was unreasonable when it charged motor carrier TCW a detention charge for returning its shipping container late, including over a scheduled and widely publicized holiday weekend when TCW knew months in advance that the Port of Savannah was going to be closed. The commission found these charges to be unreasonable because in its view, there could never be any financial incentive to return equipment on a particular day if there's no ability to return the equipment on that particular day. The commission says that its decision should be upheld by this court if it's reasonable and reasonably explained. Respectfully, it's neither. If the charge in question is intended to provide a financial incentive for parties like TCW to return shipping equipment promptly, the commission never explains in the order under review or its brief how under the facts in this case, the prospect of TCW having to pay $510 in charges for returning Evergreen's equipment late does not serve a far greater financial incentive than if there was no charge at all. The commission's no charges on closed days conclusion was based on its 2020 interpretive rule, which was intended to provide the industry guidance on how the commission was going to assess the reasonableness of detention charges in future Shipping Act cases. The interpretive rule did four things. First, it clarified that it was only guidance, no one-size-fits-all set of regulations, and no bright line rules. Second, it listed a number of non-exhaustive factors that the commission said it was going to consider when it applied its reasonable test to detention charges in the future. And third, it created the so-called incentive principle. Since the detention charges are supposed to incentivize the prompt return of equipment, the commission says as part of its analysis, it would consider whether or not there was such incentive in any particular case. And lastly, and importantly, in addition to the incentive principle, the FMC said it would consider any other facts and extenuating circumstances that parties raise on a case-by-case basis. In the order under review, the commission ignored the facts. It abandoned its interpretive rule and its prior precedent. It threw out that non-exclusive factor test, multi-factor test, and it doubled down on a single factor, the incentive principle. And it did that. It created a bright line rule, no charges on closed days. And number two, even doubling down on the incentive principle, it compounded that mistake because it got that principle wrong too. Here, when TCW knew that the terminal was going to be closed and the terminal was open for days after the equipment was due, there most emphatically was an incentive for TCW to return the equipment. They just didn't exercise that incentive. Commission itself concedes that in its brief.
Can I just ask you a very basic question, which is how you understand what the commission's rule is? So the small claims officer issued a clarification, I think, that purported to say the rule was just essentially a final weekend rule, a constructive delivery rule. If you show you would have delivered the container on a Saturday, then you can't charge for the rest of the weekend. But on appeal and other parts of the order seem to set out a much broader rule you're suggesting, which is just no charges ever on a weekend. Which of those do you think is actually the rule that's been announced?
Judge Garcia, it's a bright line rule that there are no charges on any closed days of the weekend. And the way that we know that is the commission's basis for that decision is when it said there can never be a financial incentive for a party to return equipment on a particular day if the terminal is closed on that particular day. And we also know that because if you look back at both the small claims officer's decision and the FMC's decision on appeal, it doubled down on that one factor of incentive. And it said there could not be any incentive here because it was physically impossible to return the container on that day. So Evergreen's point of view is there's no other way to read that. And in all future cases, there are no charges on closed days. The commission has decided here that that's unreasonable. And Judge Garcia, I'd mention one more point, which was we also know it's a hard and fast rule. And this was in the amici's brief because since this rule, the commission has gone to all regulated parties, including Evergreen and ocean carriers, and said, please tell us that you're complying with this rule. So it's a rule. It's a hard and fast, bright line rule. And it's exactly the opposite that the commission said they would do in the interpretive rule.
Mr. McGovern, I think the agency's answer to you looks in part to the order in this case, where it says further ordered that absent extenuating circumstances, Evergreen shall cease and desist from levying charges on those days. So they're saying, right, well, we're still waiting for someone to show us exigent circumstances. Why isn't that less than a bright line rule?
Because we did show extenuating circumstances, Your Honor, in this case. In fact, as Evergreen pointed out in its brief, if the extenuating circumstances that were present in this case were not enough for the commission to find the charge in question to be reasonable, it will never be. TCW had 3 weeks to use Evergreen's container at no cost. The container was due to be returned a full 3 days when the port was open and operating for business. TCW knew months in advance when the port was going to be closed. There was no question whatsoever.
Why was there a notice sent on Friday, the 22nd, that that the port would be closed on Monday, the 25th for Memorial? Was that known prior to that notice being sent?
It was, Your Honor. So there's 2 notices in question that you're talking about in the record. The first, we're talking about the notice of the closures on the Saturday and Sunday. Those go all the way back to March of 2020, and there's no question that there were months of notice there. Second, on the customary advisory that you're referring to that went out on Saturday to remind truckers and other parties that the terminal was going to be closed on Memorial Day, that was just a reminder notice. The full port's holiday closure schedule is available on the port's website. It was available on the port's website now. And actually, if you look at it now, you can see that the Memorial Day this year, the port was open.
Now, at one point, the answer to your concern about not delivering the 3 days before, at the end of the free time, was that the Yamaha plant was closed, not the port, but the Yamaha plant. What's your response to that?
So this is an important aspect of why the commission didn't do the necessary job that's required under the APA, because the commission took at face value that the port was closed and there was simply, or rather, Yamaha's plant was closed for COVID reasons. There was simply nothing that that TCW could have done in that case. And Your Honor, there's no evidentiary record on this. And Evergreen argued both before the small claims officer and both before the commission on appeal. We said, TCW hasn't shown you any actual evidence as to what best efforts it took.
All right, so as I read the pleadings, in your response to the complaint, you said, indeed, you denied that sentence. There's a long paragraph with several sentences, and you denied all but one or two of those, whatever it was. So you denied the allegation that the Yamaha plant was closed. There was no response to that. The SCO took it as a fact. You objected. Pardon me. So you had objected and it was taken as a fact nonetheless. Did you renew that? I couldn't find this. Did you renew that objection in what I think is called the supplemental brief, the one that goes to the commission itself?
We did, Your Honor.
Would you give me a page reference
Yes,
on that?
the page sites are JA 170, where this is before the small claims officer, where Evergreen said there's an absence of evidence on the record to prove the allegation. And then secondly, on JA 242 and 243, this is before the commission, Evergreen said, it failed to do so for reasons having nothing to do with Evergreen. To the contrary, the claimant admits that the reason for failure was the return of the equipment that was stuck at your facility. Given that claimant was the preferred trucker and claimant obtained Evergreen business at its behest, one would think claimant would have exerted some due diligence to try to get the BCO to release the equipment sooner. No such effort was shown.
That was regard to the claim of best effort to deal with the BCO. But what about specifically denying that the plant, that the SCO had accepted this assertion without evidence? Did you say that?
We did in our briefing before the commission as well. And we raised that because they're sort of one in the same, which is to say the argument that was being made by TCW was the plant was closed. And the argument that Evergreen was making was, if you actually look at the record, the plant was actually releasing empty containers during the week prior. So the plant was open. The question then becomes, what did TCW do to retrieve the container in time so that it could return it to the port of Savannah in time?
Well, then why is it that Yamaha gave you notice, I think on the Saturday in question?
That's right.
That the container was available for pickup. Just because the plant was open doesn't mean that the container was ready to be picked up, correct?
So that's right, Your Honor. So
what evidence is there, a suggestion even, that you could have gotten the container from Yamaha before the expiration of the free time?
That's our contention. Our contention is it's certainly possible, and it was up to TCW in order to demonstrate that it at least made those efforts. And the notice
they made no effort whatsoever, but they got notification only on the Saturday in question.
The notification, Your Honor, that they got, I understand the point of the record that you're talking about, actually was on Thursday. So the notification, the email that you're referring to is dated Saturday, but they received the notification on Thursday. And so in other words, they received it on Thursday and they could have picked up the container or called their customer Yamaha and said, our container is due. It's already due, but we need to return it by Friday to stop incurring charges.
And what was the date of the Thursday you said? Oh, it's the 21st.
That's correct.
I can pick it up, yes, on the 23rd. Well, they gave notice on the 21st saying you can pick it up on the 23rd, which certainly implies that you could not pick it up now on the 21st, right?
Your Honor, that's certainly how the FMC said it, but the critical question is, well, what did TCW do to, it said we took best efforts. It sounds like what they did was just got that email on Thursday and did nothing at all. And the way we know that they did nothing at all is because they didn't give you a single example of anything that they did. And you're right to point on this. This is a very important point because the commission's record is based upon two things: that apparently TCW did everything it could to get the container on time, and that they couldn't return it on afterwards. Well, it's important then TCW has the burden of proof under the Shipping Act to show that the charge was unreasonable. And to do that, it's their job to tell the commission what best efforts they took. In the commission's brief, they turned to Evergreen and they said, Evergreen hasn't given any example to refute this factual allegation. Well, the only ones who are in the position of knowing this knowledge are TCW and Yamaha. They're the only ones who can tell the commission what it is that they did. And they took a pass on that. And the reason they took a pass on that is they didn't do anything. They just,
Well, we don't know.
we don't know. And if nothing else, this court needs to remand the case back to the commission to do that factual evidentiary finding. It's critical as part of this case, because if indeed TCW did something, that might bear on the overall reasonableness analysis. But the commission couldn't find reasonableness here because they just simply didn't ask the questions and didn't do the appropriate amount of fact finding.
And you say that's because the burden is on the challenger under the Shipping Act.
That's correct, Your Honor.
It seemed to me it might also be true because the assertion is in the nature of a defense, as to which they have the facts, not you.
That's correct, Your Honor.
All right, we'll give you a couple of minutes.
Thank you, Your Honor.
Mr. Huey.
Morning. May it please the court. I'm Chris Huey for the Federal Maritime Commission. I'd like to jump right into what you were asking about, Judge Ginsburg, by starting by pointing out that this is a quasi-judicial role the FMC has in this case. It's an adversarial proceeding. And I don't think that Evergreen has alleged or shown that it didn't have enough process, enough discovery opportunities to engage in the kind of investigation that it wants to do about TCW and Yamaha's relationship here, and about the activity that went on before the container was ready.
Counsel, why is any of this discussion of TCW's efforts to get the container from Yamaha relevant when the rule the commission announced and the cease and desist order does not turn in any way on the fact or the asserted finding that TCW couldn't have done anything to get the container earlier? It's a cease and desist order to stop charging fees on all weekends, right?
It is absent extenuating circumstances. And so there's always that out. And I think that what that does is preserve that each one of these cases is decided on its facts, and that a carrier like Evergreen would always retain the opportunity to put forward an argument, a defense, whatever it might want to say, even if there were an effort to enforce the cease and desist order against them. That there's sort of a perpetual opportunity to make it about the facts of that case. And so I think that your earlier question really got to the heart of how the court wants to decide to look at this, because you're absolutely right that the small claims officer did issue something. I don't think it would be categorized as an official document. It was more in the nature of like a helpful email before the commission announced its decision to review the case, saying that sort of what you were explaining, this akin to constructive delivery, that because TCW was ready on Saturday to turn in the container, that's why the daily charges on Saturday, Sunday, and Monday were not reasonable. The commission.
My concern is, I think both of those arguments could go to showing that the fees here were unreasonable. Either that the commission wants to adopt a constructive delivery principle and explain that, or that it turned on the Yamaha plant being closed. My concern is that none of that is in the commission's order. Instead, it's an explanation based on the incentive principle that counsel on the other side focused on. And so why shouldn't we remand to give the type of explanation that you're now offering?
Well, a couple of reasons. I don't think that there's going to be any useful additional fact finding after what was a very elaborate adversarial proceeding, creating a pretty big record for a $510 case. Secondly, the incentive principle itself is what the commission relied on to decide this. And I want to get to that for a moment here and talk about how the commission looked at that and how that differs from the way that, that Evergreen would prefer to look at it. The commission viewed the daily penalty charges for not turning in the equipment on time in that way, literally as being daily charges. And so it went granular and it looked at, okay, on any particular day, is it possible to do the purportedly incentivized behavior? Well, it was on Friday, but it wasn't on Saturday. And so the Friday charge is reasonable and the Saturday charge is unreasonable. The kind of expanded incentive that Evergreen argues for, where if you don't turn it in on Friday, you have to pay 3 days worth of daily charges instead of 1 day's worth of daily charges. First of all, on the record of this case, on the facts that we have, it didn't work. TCW still turned the equipment in late, despite having what Evergreen argues is a very strong incentive hanging over their head. But more importantly, I think, is to look at it that way moves right past the fact that they are literally daily per diem charges. And are they reasonable they might be reasonable on one day and unreasonable on another day. What the agency's looking at is what behavior is supposed to be incentivized. And as we put it in the brief, you literally can't incentivize the impossible. And so why would a trucker be penalized for something that it couldn't do on that day? Now, in the record, and the commission fully supports this, TCW was on the hook for about $1,000 in late fees, and that was not questioned by the agency at all. And that's about 2/3 of the late fees that were actually in play in this case. So the commission ordered a refund of about 1/3 of them. And that's because it went granular and it looked at on a day-to-day basis, is a per diem charge reasonable or unreasonable? And it found these to be unreasonable.
Counsel, at page 8 in your brief, at the top, carrying over from the previous page, 8 to 9, pardon me. Under this deferential standard, you say, the court will uphold the agency so long as the action is reasonable and reasonably explained. Curiously, though, the next sentence after the next header is to find a violation, the statute requires that the practice be unjust or unreasonable. And that since it's reasonable, we should be denying the petition. The point about reasonably explained drops out in the second telling. But the argument in the petitioner's brief is extensively on whether you responded and explained why you didn't accept certain factors that they raised as, I guess, extenuating circumstances, if you will. So one of them, let's start with the one at 33 in the blue brief, is that the commission did not provide a reasoned analysis of whether the conduct in question was reasonable in light of the facts we just recited. And that was the first one here. That there had been this allotment of 21 days, and that the contract is provided by a contract, a negotiated but longstanding contract on the intermodal exchange addendum, that the port's operating days were previously announced. There's several different things like that. And your responses to them seem to me quite limited, let's put it that way. With respect to, give me a moment, in one instance, your answer is, well, sure we did look at, I think it was the SCO opinion, but may have been the final opinion. And all it says there is respondents argue. It's just a description of their argument. That is not an analysis of why it was unreasonable
No, I think
or
that
why you rejected it. It's just a description.
correct. So I think part of the issue there is that Evergreen is trying to frame certain issues as controversies that are not. So for example, the one that I think Evergreen highlighted most extensively is the fact that TCW knew about the closures in advance. But that's simply part of the record. TCW never said it didn't know about the closures in advance. It actually attached the closure notifications to its complaint. And that wasn't the notion that they were surprised by the closure and therefore shouldn't be on the hook for per diem was not part of their argument at all. That is a plausible argument under this regulation, but it's not the one that TCW made. So in that case, it seems like Evergreen is rebutting an argument that wasn't made by the complainant.
There are a few of these. One of them, as I say, was just all you did was point to the respondents argue. And another one, it was again pointing to something that could hardly pass as analysis or as a reasonable basis for rejecting their point. And those what shall I say, lacunae in the final decision leave me wondering what you would say if you actually took on the analysis. In one case, one instance, you say something, the commission said something that you point to later that I just simply cannot understand. It says at 304 in the JA, or page 10 of the opinion. The commission also rejects the argument raised in amicus filing that not charging during the 3 days closure would have disincentivized the return of the container before the closure. That I understand, but here's what you said, the commission says. These arguments were previously raised and similarly dismissed during the rulemaking process. Okay. First, the disincentivizing argument neglects the commercial incentives to returning empty containers, and one could easily argue the contrary position, namely that the ability to collect per diem, even if it's impossible for a truck to return equipment, might disincentivize ocean carriers and marine terminal operators from acting efficiently. What does that last part mean? What is the disincentive to which the commission is referring?
Effectively, that if there's no incentive on the other side of this equation to potentially change practices to make cargo fluidity occur, that it puts too much of the emphasis on the cargo interest side. So, for example, if per diem is being limited by a port closure, marine terminals and or carriers might determine to open on Saturdays. But under a system in which they can charge these charges on closure days, they don't have an incentive to consider something like that. They consider a different and potentially more efficient approach to their hours, to their equipment return policies. In other words, that it puts all of the pressure of innovation and all of the risk on the shipper side, on the cargo interest side, on the trucker side in this case.
So why does that outweigh the positive incentive to early return on the trucker if Evergreen's position was adopted? It's certainly, you've described that not allowing weekend charges or allowing weekend charges might incentivize some form of bad behavior by the terminals. You know, where's the explanation of why that outweighs the positive incentive to return containers early?
I think that this is balanced with an overall focus on reasonableness. And so again, it's getting granular, and is the charge on a particular day reasonable or not? These are underlying kind of big picture policy arguments about this, but I don't think that they get to the actual like rubber meets the road of the commission's decision here, which is looking at specific days and specifically whether the purportedly incentivized behavior can happen. And so if that discussion is confusing, and I certainly see that it is a run-on sentence, and we apologize for that. But if that's confusing, I think it still doesn't get to what the commission was fundamentally concluding here about per diem literally meaning per diem. And you look at the charges on a daily basis to evaluate and adjudge their reasonableness.
When Evergreen makes the point in their brief at 44, and we heard it earlier today, and I think you began to address it. The critical flaw in both the SCO and the commission's reasoning is they both look at each day in isolation and improperly conflate TCW's ability to return the equipment on that day with the broader incentive to return the equipment promptly. It's again at 44. And the commission's answer to that apparently was in the commission's opinion, not in the brief. In this case, there was nothing claimant could have done to return the container between May 23 to 25 because the port was not receiving containers. The SCO correctly found that the per diem charges were unreasonable because they could not have been incentivized cargo movement given that the port was closed on those days, making it impossible for the claimant to return the equipment. The counter was, of course, that well, if there's a penalty that's going to accrue on Saturday, the incentive is to return the equipment before Saturday, and that doesn't have to be on Saturday, right? It could have been indeed free time ended on the 21st, I think it was. So there was an incentive to return it by then, and the incentive grows each day. And the fact that the fact that it couldn't grow, or pardon me, that they couldn't deliver it on those 3 days simply means that the incentive to deliver it on time is even greater.
Your Honor, the commission's position is that it has to be a reasonable incentive, in other words, closely tailored to the purpose. And so the agency's conclusion here is that a sort of supersized incentive of 3 days worth of charges for being 1 business day late isn't closely tailored enough to the goal. And it's not reasonable because they couldn't do the thing that's being incentivized. The Friday charge stands, the Tuesday charge stands, and all the preceding days before that all stand. But in the agency's view, it really turns on, is the incentivized behavior possible?
But why is, right, so imagine, you just said the Tuesday charge is fair. Imagine they return the container on a Wednesday and a Thursday. What charging fees on the weekend is doing is incentivizing the trucker to continue taking steps to get it to the terminal on Tuesday or Wednesday, right? It's not that just because the port is closed doesn't mean that you can't place incentives on the carrier, the trucker, to still be working over the weekend, right? I'm just not sure how that logic holds up.
So again, the commission has to make sure that these incentives are reasonable incentives and closely tailored. And so it's the agency's expert opinion on this, that it's not reasonable to charge on days when you can't do the incentivized behavior. Does a supersized incentive of many days worth for being 1 business day late further incentivize? Well, as I mentioned earlier, in this case, it sure didn't, because they were still late. Abstractly, does it do that? Maybe. Is it reasonable though? And is it rational? I mean, the fact of it being a 3-day weekend by the time TCW got notification of the container being ready is a coincidence. Is that a rational system to base charges that are supposed to be closely tailored and that the commission is looking at on a granular day-to-day basis to make them subject to such happenstance? So we would say no.
All right, thank you.
Thank you.
Mr. McGovern, why don't you take 2 minutes?
Judge Henderson, I'm sorry, couldn't hear you.
What?
Couldn't hear you asking the question.
Oh, Mr. McGovern, would you come back up to the podium, please? Judge Ginsburg has a question. Mr. Huey, I keep getting your name mixed
I'm
up.
sorry, I was thinking he's already there.
I'm sorry, I was distracted. I'm not sure I caught your answer to, I think it was about discovery as to when the complaint made about the commission accepting, the SCO accepting the assertion, the pleading that the Yamaha plant was closed. And what did you have to say about that? That the Evergreen didn't avail itself of discovery on the question?
So, yeah, my point, Your Honor, is that this is an adversarial proceeding. The commission's in a quasi-judicial role here, and Evergreen hasn't alleged that it didn't have enough process to try to find these facts that it supposes exist. There's no evidence for in the record.
Well, I don't think they said they didn't have enough process. I may be mistaken, but they were complaining that the assertion was accepted, although there was no evidence, just the assertion.
The evidence, I think, was what you referred to earlier about the attachments to TCW's complaint showing the emails from Yamaha showing that the container wasn't ready until that Saturday. That's unrefuted. Evergreen didn't.
Actually, the notice wasn't that it was unavailable until Saturday. It was that it would be available for pickup
On Saturday.
Right. But there had been pickups at the plant on other days that week and the previous week. So I don't think we know when it was first available.
The other thing in the record on that is TCW, which because this was a small claims proceeding, it wasn't represented by a lawyer. It was a vice president from the company itself filing the documents. And the complaint where he says we couldn't turn in the equipment until Saturday was sworn. And so that's in the record as well. And I don't see anything where Evergreen has not had ample opportunity through multiple rounds of briefing to bring out additional facts that it supposes.
That's a burden on the challenger to the practice.
The evidence that existed in the record on that point, though, was unrefuted. And that's why the small claims officer made that finding.
So the small claims officer was both making a finding. Well, actually, I don't know if he made a finding. He just accepted it, repeated it as though it were established, and then did not, and then drew an inference from that, correct? That it could not have been picked up earlier.
I think that's right, yes.
Why would the Yamaha give notice that it could be picked up on Saturday if the plant was closed? As the commission's position has been that the Yamaha's plant was closed the whole time.
I don't know what Yamaha's COVID restrictions were, how they implemented that. In the emails that you referred to earlier, there's a long list of available containers. This was only one of them. It looks like dozens maybe of containers.
Correct, but on various dates.
Yes.
This particular container by ID number shows up only on the Saturday.
Mm-hmm. Yes, no, that's absolutely right. And there's others on the list, and you have to kind of dig around and find the particular container on that list. And again, I don't see that Evergreen didn't have ample opportunity in this adversarial proceeding.
Well, why can't they say this, you know, this is the challenger's burden?
And we have the emails from Yamaha and TCW swearing that this was the only opportunity they had, first opportunity they had to pick up the container.
Well, Yamaha says they made, pardon me,
TCW?
TCW maintains that they made best efforts, right, to deal with the BCO to arrange delivery. But what evidence is there that they made any effort?
Again, we have their sworn testimony and we have those emails and we have nothing from Evergreen.
Did they say in that sworn testimony anything that they did, or does it say we made best effort?
More of the latter.
Yeah. Thank you.
Thank you.
Mr. McGovern?
Thank you, Your Honors. The agency just told you what its analysis was. It told you that it applied a single factor and asked in its entire reasonableness analysis one question: was the terminal open on that day? That's it. And then the agency just told you if there's no ability to return on that one day, then there's no incentive to return at all. And we submit that that's illogical and unreasonable. The agency suggests it's the expert agency, but the agency is not an expert on the general concept of incentive. And by analogy, I offer this. Let's say that I have a library book that is due this past Wednesday, and I know that the library, one, is going to be closed this weekend, and two, that charges will incur if I don't return the book before that closure. Now, I am incentivized to get to the library today as quickly as I can so that I can avoid those charges because I know it's going to be closed and I know the charges will incur. But if you tell me that there will be no charges over the weekend, then I have no reason, no incentive to go to the library today and return my book. I'm just going to wait until Monday. So that's the commission's incentive analysis, and that's the effect of its order. And that's why it's illogical and unreasonable. As it relates to TCW's knowledge, we are most certainly rebutting the FMC's analysis on that. They are incorrect there. The FMC says on this critical issue that TCW had prior knowledge of the port's closure, the FMC told us in the order, we already considered that issue, pointing generically to the interpretive rule, where it pointed to situations involving uncommunicated and untimely communicated terminal closures where there was no notice at all. That's completely the opposite of the situation here, where TCW had months of notice. So the FMC can't say that they considered the most critical fact in this. They did exactly what this court has told agencies it cannot do. It recited the facts, it jumped to the conclusion, and it ignored the rest of the facts, and it didn't give you the reason explanation as to how it got there.
Can I ask you just briefly about that? So what you mainly just talked about is the substantive reasonableness of the commission's rule. And you also raised, obviously, a reasoned decision-making argument. And one of the focuses of that is, why is advance notice, an expected closure, not different from an unexpected closure? And, we will uphold decisions that are, less than clear. And I take it to be FMC's position, essentially, that our fundamental rule is crystal clear, as you put it. If the port is closed and can't be returned, there's no incentive. And so it's just sort of obviously irrelevant whether the closure is expected or unexpected. So only in terms of a reasoned decision-making argument, what more do you think should have been in the commission's decision to explain why advance notice is irrelevant?
Your Honor, it makes all the difference in the world because if a party has advance notice, they have the opportunity to plan ahead and change their behavior in order to return the equipment on time. So Evergreen says two things. Number one, the commission is telling us that the Evergreen didn't act on its evidentiary record. We asked the question, we raised the question multiple times saying, you haven't asked TCW what it's done. So it doesn't have the record right now to even find that the charges here were unreasonable. What we would require the FMC to do is ask those questions and then do a full analysis of all of the facts, do a full analysis of the fact that TCW knew that the port was open when free time expired, do a full analysis of the fact that TCW is a commercially sophisticated entity. It contractually agreed upfront that it was going to pay Evergreen detention charges, including on weekend and holidays, and including the fact that Evergreen played no fault at all in the delay. We would ask the commission factor all of these and then provide this court a reasoned explanation why these charges are nonetheless unreasonable.
Well, I'm sorry I didn't raise it with the commission, but as you remind me now, factors you just recounted included, and some of them traced back to the contractual point, right? These were sophisticated parties who had entered into a negotiated contract. To which, as I recall, the commission's response was that they have jurisdiction under the Shipping Act to override a contractual provision, and that's certainly true. Full stop.
Your Honor, if you
I
look
mean,
at,
I didn't see any response as to, sophisticated parties, presumption that they would know what they're doing. So,
Your Honor, you didn't see a response because they didn't give you a response, either in the order or in their brief. If you look at the interpretive rule, they said one of the factors that would be considered in this multi-factor test is the contractual situation of the parties and what they were concerned about. Again, it's important to look at the rule. The FMC didn't do this. What they said was, we're concerned about bargaining power here. We're concerned about one party taking advantage over another. Again, under these facts, in this case, we don't have that. We have two commercially sophisticated entities that went in upfront and made a contractual agreement that detention charges would apply. Every day the equipment was returned late, including weekends and holidays. TCW went into this transaction knowing full well that weekend and holiday charges would apply. And it had knowledge that the terminal, when it was going to be open and it was going to be closed.
but
And
I don't
Evergreen.
doubt that the commission could overrule that, could reject that, because it says it has jurisdiction to do so.
All Evergreen submits is that.
Narrower, it's that they didn't explain why they would override the contract.
That's right, Your Honor. And that Evergreen's position is this is one of many reasonableness factors that the commission failed to consider. So if the case is remanded back to the agency, then the agency can consider it just as you suggested, Your Honor.
Thank you.
Thank you very much, Your Honor.
Case number 22-7154. Cameroon Whiteru, individually and as personal representative of the estate of Okimu C. Whiteru and Agnes Whiteru, appellants, versus Washington Metropolitan Area Transit Authority. Mr. Levy for the appellants, Mr. Shaw for the appellant.
Mr. Levy, is it pronounced Levy or Lee?
Levy, but I answered either one, Your Honor.
All right. Okay. Well, Judge Ginsburg has told us to go ahead. So let me ask you first, and I'll ask the other side as well. What is your position on certifying this issue to the local court of appeals? That is, which restatement provision?
May it please the court, Andrew Levy on behalf of the plaintiff appellants. Obviously, that is a matter within the discretion of this court. The appellant's position is that while this is a case of first impression in that there's never been, there is no case on all fours directly on point, that just as this court felt itself capable of deciding the question in Whiteru 1, that there is no reason that this court is not, does not have the expertise and the knowledge of DC law to decide this question. Yesterday was 10 years to the day since Oki Whiteru paid the required fare, went into the Judiciary Square metro station, and several hours later died a slow, painful, and completely preventable death. The issue, the controlling issue, is whether WMATA's special relationship with Mr. Whiteru continued after he stumbled and fell backwards into a place passengers were not permitted. Had he fallen forward, of course, there would be no question and we would not be here. Can it be that the special relationship turned on the happenstance of which way he had the misfortune to fall backwards or forward? In Whiteru 1, this court held that in the case of contributory negligence, the Section 314A special relationship took the case out of the general contributory negligence rule, that notwithstanding his contributory negligence, if WMATA knew or should have known of his plight, it had a duty to take reasonable steps on his behalf. The answer we respectfully submit should be no different for the general trespass rule under Section 329. It is explicitly referred to as the general rule, but as the commentary to Section 314A notes, the special relationship, quote, takes the case out of the general rule. The Section 314A duty to aid did not end when he fell and cried for help. That's when it began. To interpret the rule so that the very moment Mr. Whiteru most needed the carrier's assistance was the moment he lost it, would, we submit, be bizarre, and it is not required by DC law. And we begin with the statement that you see in the Genty case and in the Gould case, that all of the decisions with respect to the trespasser standard recognize that it is always contextual and that the carrier's relation to and duties towards passengers constitute the critical context. Here, the context is that there was a special relationship between Mr. Whiteru and WMATA. It is the nature of a relationship, unlike, say, a status, that it is not a bubble that bursts upon the happening of a certain event. And all of the cases relied upon by WMATA to hold that a trespasser, that there's no requisite duty on behalf of a trespasser, are distinguishable in critical respects. Either there was no special relationship, or in the case like Hines, Johnson, where the individual had chosen to go on the tracks, there's the notion of forfeiture, and which is not present in this case. Plus, all of the cases cited by WMATA, all of the cases on which they rely, dealt with a liability for a primary injury. And here, no claim is made for Mr. Whiteru's initial injury. The claim, as in Whiteru 1, was that once he was in the position he was in, should the mere fact that he had accidentally fallen in a place passengers were not permitted.
Let me say this, that I think WMATA's authorities are not only distinguishable, I think they're inapplicable. 314A uses this Yazoo old case from the 20s or earlier to prove its point. And there's no way to read Yazoo except that that man was a passenger when it mattered. He was on that platform. They knew it. Well, they didn't know it until the other passengers told them. He fell onto the track. Still, they didn't rescue him until later, but they had the duty to rescue because at the point it mattered, that is when he fell, he was a passenger. I don't see how you can read that any other way.
Well, obviously, I agree with that completely, Your Honor. And I will say that the district court, who characterized this as a hard but nuanced issue, it broke the tie between the competing restatement sections by going and looking at the Yazoo case and saying, well, that's the restatement didn't really capture what that case actually held. And that, frankly, is irrelevant. The DC Court of Appeals did not adopt the cases that underlie or that generated the comment in the illustrations. It adopted the restatement itself and the comments and illustrations that were there. And it is certainly the case that the comment about the passenger who negligently falls off and there is a duty to come to his aid is not only on all fours with this case, but the competing Section 329 illustration dealt with, again, a general rule. It only addressed the question of a primary injury, not the duty to come to the aid to prevent an aggravation of that injury. And I guess where I ultimately come down, Your Honor, is that more than one thing can be true at a time. When this court is faced with two seemingly contradictory statutory provisions, you don't feel compelled to choose one over the other. You make an effort to reconcile them and see, are they really irreconcilable? Is it truly a binary choice, as the district court seemed to believe? And I see into my rebuttal time, so I would like to leave note what we see as an analogous situation that is maybe more familiar to everybody, because the facts of this case are somewhat unusual and bizarre. But if you think about an innkeeper who has the same duty as a common carrier, and a guest of the hotel has some sort of a seizure and accidentally falls into a fountain in the middle of the lobby. Well, everybody knows guests aren't allowed in the fountain in the middle of the lobby, but could it truly be said that a guest in that situation, that the innkeeper has no duty to take reasonable steps to come to the aid of that individual?
Mr. Levy?
Yes, sir.
Yeah, of course. But the facts of the case that Judge Henderson recounted depended vitally on getting notice from a fellow passenger about the accident. In this case, it seems you're imputing constructive knowledge to WMATA because there's no evidence of actual knowledge, correct?
There is no evidence of actual knowledge, but we don't think that is a distinction that matters, Your Honor. The restatement.
So if someone falls into a place where they could not be discovered by any means.
It's reasonable steps, Your Honor. That's what we're talking about. And
right,
it
so
is
because the question is one of negligence.
Correct.
Yeah, and so what constitutes a reasonable step in a negligence context is a precaution that is justifiable in view of the potential for injury. And here, what was it that WMATA could or should have done that would have discovered the accident in a timely fashion?
Your Honor, it is the law of the case that WMATA, and I believe undisputed, that
they have an inspection.
It was certainly a triable. This is not undisputed, but it's certainly a jury question as to whether they should have known, whether they knew or should have known. And the standard is always phrased as knew or should have known. There's no suggestion that constructive knowledge is not enough. And if
you should have known, I'll accept that. That's
okay.
That's really what we're talking about.
The record, Your Honor, is that both WMATA's internal standard operating procedures and the national standard required the station manager to walk the station end to end.
Platform, walk the
Walk the platform end to end, and to specifically look in places where a person might hide or where a package might be stacked. It's also the forensic
My
evidence.
understanding is that there is some evidence, testimony on the record that inspection, because of the upward lights on the barrier, would not have revealed the person lying there.
Jury question. That's a tribal issue of fact. And the other thing I would add with respect to constructive knowledge, whether it's, as WMATA argues, only actual knowledge is enough, that would create such a perverse incentive to the carrier to almost engage in willful blindness.
No, no.
Counsel, can I ask a clarifying question about what's before us?
Yes, sir.
As you know, there's two aspects to the duty to aid. The person has to be a passenger and there has to be a reason to know. My understanding was that WMATA moved for summary judgment in this motion just on the ground that he is categorically not a passenger. They've not moved for summary judgment on the ground that there's no dispute of fact as to whether there was a reason to know. Is that right?
I believe that is
Thank you.
correct in the record, Your Honor.
Oh, we'll know more in a minute.
Have you more? Okay, we'll give you a couple
Thank
minutes.
you, Your
to
Honor.
reply. Thank you. Yeah, good morning.
May it please the court, Pratik Shah for appellee WMATA. Binding precedents applying DC tort law make two principles clear. One, a passenger becomes a trespasser when he enters a restricted area, even if accidentally. And two, such trespassers, at least if unknown, are owed only a duty not to be harmed through willful or wanton misconduct, not the special 314A duty to aid. Those entrenched principles of DC tort law resolve this case. It's not just about reconciling the two, it is about reconciling the two restatement provisions, but there is a long line, a 4-decade line of unbroken cases from both this court and the DDC, relying on Furfer, Holland, and Copeland. Those are the DC Court of Appeals precedents that are consistent with restatement section 329 that hold this: a WMATA passenger who leaves the platform into a restricted station area, whether intentionally or accidentally, becomes a trespasser.
Counsel, I'm sorry to
Yes.
interject, but I want to ask you about
please.
the very first thing you said.
Yes.
You said DC case law is clear.
The
that it-
DC tort, binding precedents applying DC tort law, yes.
Okay, so, and the question in our case is, when does a paying passenger
Yes,
lose, whether they lose passenger status
Yes.
or exempted from the duty to aid because of a accidental trespass? Which
Yes.
DC case holds that they lose that
yes.
status?
Okay, I'm going to answer that directly. There are two cases. If you add them together, answers your question perfectly.
Furfer and Holland and Copeland.
No, I'm going to start with actually a case of this court. The DC Circuit, we cite a half dozen cases that are from DDC on pages 14 and 15 of our brief. One of those cases, though, was actually a decision by this court. We cited about a half dozen times. That's the Johnson case. In our brief, we cite the district court citation that was on remand from this court's decision, which quotes the rule that this court cites. But let me give you the cite to this court's decision itself. It's 883 F2D at 130. That's the Johnson case, again, cited about a half dozen times in our brief. Here's what this court said, quote, under DC law, plaintiff, a fare-paying passenger, became a trespasser when she jumped onto the tracks and thus may only recover for intentional, wanton, or willful injury, end quote. Then you take the DC Court of Appeals decision in Copeland, which rejects any distinction between jumping and falling onto the tracks. Those two cases together, both binding on this court, Johnson because it's a decision of this court, Copeland because it's a decision of the DC Court of Appeals.
So I'm not saying this is wrong. I just want to make sure we're on the same page.
Yes,
The DC Circuit case did not address an accidental trespass, right?
accidental, it was intentional, correct.
Okay, thank you.
And then you take that decision, which says a fare paying passenger, just as you said, a WMATA fare paying passenger becomes a trespasser, no longer entitled to 314A when they end up on the tracks. You combine that with Copeland, DC Court of Appeals decision that says, quote, whether it's intentional, accidental, or inadvertent does not matter with respect to trespasser status under the restatement. That removes any daylight between those cases and this case. That's exactly this case on point. When you add up this court's binding decision and Copeland's binding decision, you get this case.
So I very much appreciate the adding those two principles together.
Yes.
Just more directly though, what would the logic be of this rule? What purpose does it advance?
Sure.
If we concede that the person, if he fell the other way, he'd be owed a duty to aid, but because he fell into a restricted area, you say he's not.
Sure. So the reasoning which we cite in their brief that comes from FERFER and the DC Court of Appeals reasoning is because you have to look at, it's the duty of the landowner or the common carrier, and that person shouldn't have a duty to aid, right? Or a special, even the ordinary negligence duty, they say, but certainly not a duty to rescue when someone goes into an area that's off limits, when they become a trespasser. That's the rationale behind the tort rule. But whatever, and I can understand a competing rationale, certainly, right? That no, you don't want them to do it. But the point is the DC Court of Appeals has already chosen that that's the rule. They've adopted that rule. The DC Circuit applied it in Johnson, and the DDC, I have the additive principle, you have to add them two together. The DDC has added those two principles together already in both Whitaker and Hines, which again are cited in our brief. Those are exactly the question you asked me, Judge Garcia, an accidental falling into an area of the train station that's off limits. That's both Hines, that person was senile, so didn't quite have the intentionality you would impose. And then we have Whitaker from 1984, 40 years old. That person was intoxicated, just like Mr. Whiteru. So you have the binding precedent from Johnson, you have Copeland, then you have DDC applying Johnson and Copeland in both Whitaker and Hines.
Absolutely. And I'm still just trying to figure out. So if this was in front of the DC Court of Appeals, they would say,
Yes.
they certainly could say, we don't have a case directly on point. We haven't addressed whether these two principles combined yield the result you want. And if they were to ask why, what principle of tort law is served by saying that the special relationship to a passenger ends because they fall half an inch over the line into a restricted area, right, as opposed to on the platform?
Well, the rationale is the one that I've given you that we say is you don't put the burden on the landowner or the common carrier when someone enters a restricted area. They shouldn't have that same ordinary duty. That's the whole point of the trespasser rule, whether it's 1 inch over or 100 feet over the line. That is the rationale, is when you're somewhere where you're not, this goes back to FERFER, the DC Court of Appeals decision from 70 years ago, right? With respect to the Jefferson Memorial. Yes, lots of people are invited onto the Jefferson Memorial, but when someone goes into the grassy knoll behind it that's not restricted, then they don't get the same protections or the same ordinary duty of care. So I think the important point is when you look at these cases, they don't have a single.
I'll try to have
DC
this be my last question.
Okay, of course.
So on FERFER, right, this case is as if Mr. FERFER was in the Jefferson Memorial, tripped and fell down and landed in the grassy area.
That's right.
And the question is whether
it would have come out the same way.
Anything is different in the sense of saying it certainly could be very different in terms of a reason to know. This is not about whether you have to inspect those areas, but it is about whether there's a duty to aid. So if an employee sees the person down there, is there a duty to aid, or are they just now a known trespasser?
So let me give you two answers. One is, of course, the court that decided FERFER is the same court that decided Copeland and said expressly, whether you trip and fall Copeland was even worse. He was unconscious and they put him on the tracks. So I am fully confident that unless the DC Court of Appeals was going to reverse itself from Copeland, whether you trip and fall into that grassy knoll intentionally, accidentally, or inadvertently, that's the phrase Copeland uses, same duties apply, Your Honor. Now, there is a question and Judge Ginsburg, I think you touched on this, if the person actually saw them, right? You don't have to decide that in this case. You could leave that question open because it is undisputed that it was unknown that Mr. Whiteru was there. And it's not just a constructive knowledge test. It's an actual knowledge test. That comes from the DC Court of Appeals decision in Copeland, which said there's one duty until you discover the trespasser. That is, when you haven't discovered him, he's unknown. It is the wanton, willful misconduct duty. Obviously, no duty to rescue. But once you discover, that's the word that Copeland uses. Once you discover that person,
And why didn't they discover it from the surveillance camera, which shows him falling backwards?
Your Honor, it wasn't known at the time. Of course,
What do you do with those surveillance?
Those surveillance cameras are there, but someone is not watching the surveillance camera every second of every day. So in that 2 seconds, it took him.
Maybe they should be, and maybe that's a jury question.
Well, Your Honor, they themselves have disclaimed any violation of any, their claim isn't that WMATA was negligent in not preventing his fall or seeing it. Their claim is that they didn't rescue him, Your Honor. That is the claim. And I want to point.
Because they either knew or had reason to know.
Well, here's the,
I think it's a jury issue whether they had reason to know.
Well, Judge Henderson, respectfully, you would be right if that were the right standard, knew or reason to know. But under the DC Court of Appeals, for a trespasser, as opposed to a passenger, you're right. If it were a passenger, that's the standard. 314A says no or reason to know. But once you're a trespasser, the DC Court of Appeals in Copeland said, no, it's actual discovery. And I want to point you to Estrada. It's on pages 18 and 19 of our brief. Here's what Estrada, another DC Court of Appeals decision, says exactly, Judge Henderson, on this question of constructive knowledge versus actual knowledge. It says, quote, the duty to abstain from willful or wanton misconduct does not arise unless the owner has actual, rather than merely constructive, knowledge of the trespasser's presence on the property and is cognizant that he's in danger of immediate rather than merely possible harm.
Right, so if he's in the trespasser box and not the passenger box,
That's
there's no.
Absolutely.
Okay.
And it's an actual knowledge, whether he's a known, not should have known. It's not that they should have discovered him. The DC Court of Appeals said that's not the standard. It says when it comes to trespasser, yes, if you actually know they're there, then maybe a greater duty applies. You don't have to decide.
He was a passenger on that ledge.
Absolutely.
He fell. He was still a passenger. We can argue about whether when he hit, he was a trespasser. But you can't explain Yazoo any other way than when that fella fell off the platform and hit the tracks, the railroad had the duty to aid him.
Sure.
You can't read that except to construe he was a passenger when it mattered.
Judge Henderson, I agree with your reading of Yazoo. The distinction I would draw in Yazoo is that it says specifically in the case and in the restatement that the conductor, the train crew discovered it. They knew he fell. They saw him. They were notified by a passenger and they saw him. So that takes him from the unknown trespasser, like this case, into the known trespasser. That quote that I just read you from the DC Court of Appeals is completely consistent with Yazoo. I completely agree.
And I think it's a reason to know, and that's a jury question.
No, but that's what Estrada says. No, it's not a reason to know. They said constructive knowledge is not enough. So that's when you have to reconcile 314, which I agree with you, Judge Henderson. If that case, if the train crew didn't actually know he fell, then that case would be a big problem for me and I would lose. The problem is, in that case, it says explicitly, and in the restatement and illustration, it says the train crew discovered him. So you can reconcile 314A, and that's this court's job, reconcile 314A and the on-point illustration in 329, right?
Counsel, can I just on Yazoo?
Yes.
It held there was a duty to aid, right?
A duty, well, it didn't discuss the trespasser, but yes, a duty to aid because they knew he was there.
My clarifying question. My understanding is that even a known trespasser is not owed a duty to aid. It's owed a different duty to prevent harm.
Right.
So
Yes. So
Yazoo says
yes,
that there was a duty to aid,
okay.
despite technically being a trespasser.
Well, so here's where I would push back on that, Judge Garcia. Again, I don't think you need to resolve this because he was known and the person here was unknown. It's not constructive knowledge, actual knowledge. But even taking that, putting that aside, here's the difference. In Yazoo, that was a 1906 Mississippi case. What happened is this person's, if you want to talk about Yazoo, again, the restatement doesn't go into any of this, but if we're going to bootstrap into Yazoo, what happened there, 1906 Mississippi case, he ended up on the side of the tracks in a grassy field. It's unclear whether he was a trespasser. That could have been public land, that could have been the railroad's land. The case doesn't analyze trespasser. That's what the illustration in 329 does, which is based on a different case, Frederick. And in that case, we know 329, there's no daylight between 329 and this case. It's an unknown person who is a trespasser that accidentally falls through no fault of his own into a subway, right? And the court says it's wanton, or I'm sorry, the restatement says apply the wanton willful misconduct standard that's in the restatement. So if you're going to parse between the two restatement sections, 329 is actually more on point. But the job I think of is this court is to read both the sections as a whole, as my friend Mr. Levy said, and reconcile it with the DC court cases, Johnson, Copeland, Estrada. They have not cited you yet today a single DC case that's even in the ballpark of Johnson, Copeland, Whitaker, Hines. All of those, you put them together, unbroken line of 40-year cases that say when you have an unknown trespasser, whether intentionally or accidentally, and these are all WMATA cases, right? Falling into a restricted area, you don't owe a duty to rescue. You don't owe that special duty, just the duty to refrain from wanton, willful misconduct. And obviously, the failure to find him wasn't wanton or willful. And for that reason, Judge Boasberg got it exactly right.
Thank you.
Thank you, Your Honor.
Mr. Levy, why don't you take 2 minutes?
Thank you, Your Honor. Copeland has nothing to do with this case. It doesn't help this court answer the question because Copeland had never been in a special relationship with, he had never been a paid passenger. So there was no question of whether 314A took it out of the general rule. So Copeland is irrelevant. The Whitaker, the Hines case, those cases all involved volitional conduct. There was, plaintiffs had a theory that the senility took it out of it or the intoxication took it out of it, but that was not accepted. And so those cases have to be understood in the context of a volitional act. And again, they also dealt only with the initial injury. They didn't speak to the aggravation of the injury. But my gestalt with respect to the appellee's presentation is that we are not arguing about the finer points of trespasser law. In all of those cases about that it's got to be a known trespasser versus an unknown trespasser are beside the point in this case, because there's no question that as a result of the special relationship and Section 314A unambiguously uses the standard knew or should have known. So if the duty that existed between WMATA and Mr. Whiteru was that between a paid passenger and a carrier as it was, then all of that case law cited by counsel is beside the point. That's all 329 law. It's not at all 314A law.
All right, let me ask you one thing. Mr. Whiteru wouldn't have even been in the metro stop if WMATA hadn't decided to extend its hours in order to protect inebriated people.
Exactly right, Your Honor.
All right. No question. Thank you.
Thank you.